session.
Be seated, folks. We have a dispute.
Not really, Your Honor. By stipulation, we're going to play Tamika Hawkins' former testimony. There's a transcript on the bench for the court and for each of the jurors in the state. We just needed to have the court adjust the volume and make sure that's working before we brought the jury out.
Okay. And do you want me to say anything as to why we're doing this?
I would like that, yes, sir. And it doesn't have to be very specific. It's a family medical emergency that prevented her from being personally present. I had talked to Mr. Fuchs about that.
Mr. Dugan? Have a problem with telling she had a medical problem. That's why we're using this.
That's fine.
Okay. You want to play it just a moment and see?
Yes,
I don't know that I control that body.
We did call IT, so they should be down in a second.
Mike is here, Judge.
Huh?
There it is.
You tried it and it didn't sound right?
It's playing right now, no sound is on.
Okay. We separated out the controls, so I would only have these microphones. Have the attorneys muted, that would change effective, would it? Huh?
No.
From here, okay.
All right, let's have a jury, please. Got your next witness?
Yes, sir, she's coming.
All rise for the jury.
All right, everybody be seated. Sorry, we had a technical problem, delayed things. Just retrieve those transcripts if you would, Deputy. We were gonna play you a video and we can't get that to work, so we're gonna move on to something else. We'll play with that later. Mr. Prince.
This time, Your Honor, the defense would recall Joellen Brown.
All right, come forward, Mr. Prince. You remain under oath. You may have a seat. Slide up the railing, please.
Good afternoon.
Take your name for the record, please.
My name is Joellen Brown.
You may proceed.
Thank you, Your Honor. Ms. Brown, since you were on the stand last, you had an opportunity to analyze Mr. Avila-Canones' electropharogram and compare it for possible inclusion to the mixed profile developed on defense composite exhibit 1A, 1B, which is the swab of the foam cradle from the victim's house. Is that right?
Yes.
Before we get into what your finding is, I'd like to kind of go through and have you explain the numbers that you used to do inclusion and why you arrived at that opinion. So we'll look at the profiler page first. Ultimately, based on the foreign allele numbers showing up here, that is numbers foreign to the victims, were you able to do inclusion to the mixture for Mr. Avila-Canones?
Yes.
Okay. And can you tell us which alleles that you used at the various locus to do that?
Well, I was looking at the minor donor, and the major donor is consistent with brandy. So At D3, there's a 1517, and that's Brandy's type. So I called the minor donor inconclusive. Generally speaking, because it's in this position, we would think that any minor donor's alleles would show up. However, they could be masked by the 1517 of the major donor.
Does the fact that there's a slight peak disproportion there, even if it's still within the accepted percentage ranges for a single donor, is that what you mean when you say it could be masked? For example, the 17 is roughly 100 RFU higher.
That difference is insignificant
Oh, okay.
in terms of trying to include another person.
Okay.
However, I just would say that Mr. Avila Quinones at D3 is a 1517 as well.
So no determination could be made about him at
Correct.
that? Okay.
Correct. So here at VWA, I have a 14, 15, 17, 18. The two major peaks are 15, 18, and that's consistent with Brandy's type. The minor component is 14 and 17. However, I'm taking into consideration that the 14 could be from the girls, because this peak right here, 15, normally there will be a small peak right in front of the first peak. That's just a product of the multiplication that we do through the PCR process. It's called stutter.
Can you tell the jury just a little bit more about what stutter is and how it occurs?
Well, stutter is just a kind of an artifact of amplifying the DNA. It's just one repeat short of the main peak, and it's recognized that it happens. If we had bigger peaks, we would be able to see more of the stutter, but these peaks are so small that we don't see it. Okay. And the reason, so part of this 14 peak is probably stutter from this peak, which is 624 RFUs. However, that would not account for all 134 RFUs from this peak. So it must have been coming from someone else. Could have come from the girls. I was considering the kind of thing that came from their home could have their DNA on it. However, there's not enough of their profile in this mixture, total mixture, for me to be able to say they're included. However, I was still taking into account that it's possible that some of the 14 would come from them. Anyway, Mr. Avila Quinones at VWA is 1718.
Okay.
So out of these four alleles, there is a 17 and 18. So he would be included there. And there are no alleles that are stars. So this is one that could be used for statistics.
All right.
At FGA, I have a 21, 24, 25, and 26. The major component is 24, 26, and that's consistent with Brandy's type. So the minor component is 21, 25, although both of these are starred alleles. So this locus I would not be able to use for statistics. And Mr. Avila Quinones' type is 21, 25. Amylogenin does indicate that there's some male contribution there because there is a Y, much smaller than the X. At D8, there is an 11, 12, 15. Brandy's type is 11, 15, that's represented there. And the 12 is a minor. And Mr. Avila Quinones' type at D8 is 12, 12. So he would be included there. And there are no starred alleles there, so I could use this locus also for statistics. Yes. At D21, the only peaks showing up are the major peaks, which are 25, 28. So I called the minor inconclusive here. For D18, the major component is 17, 19, which is consistent with Brandy's type. So the minor component is an 18 at D18. And Mr. Avila Quinones' type is 15, 18. Now there's no 15 there that we can see, because these are very, very low. The 18 is only at 79 RFUs. And again, what I called the minor component is 18 plus. And plus means that it's possible that there's another allele that could have dropped out since this is so low.
And we're on the far right side of the graph there, so we would expect more dropout than on the left side, correct?
Correct.
Okay.
At the next locus, which is D5, I have a 7, 11, and 12. And again, I mentioned the first time I testified that the girls had this kind of rare allele, which was a 7 at D5, so I wanted to consider that their 7, which is only at 78 RFUs, might be showing up there. So Brandy's type is 1111, so that's the major type. And Mr. Quinones's, Avila Quinones's type at D5 is 1112. So he would be included there, but I could not use this for statistics because there are starred alleles there. The 7 and 12 are below 100 RFUs.
That's likewise why the girls can't be included, because both of the locus where they're potentially showing up are starred allele.
Right.
Okay. All right.
As I also said before, we can use starred alleles to eliminate people or exclude people, but not to include them.
Yes, ma'am.
At D13, the alleles I found were 11 and 12. Brandy's type is 1111, so the 12 is minor. And Mr. Avila Quinones at D13 is 1112, so he would fit in there.
All right.
Then there were no results at D7 on Profiler Plus, but there are on Cofiler.
All right, so now we're on the co-filer page for the same exhibit. What do we see over there?
Okay. This is again D3, which was on the Profiler, the first one on Profiler, and it gives the same results, 15, 17, which is consistent with Brandy, and I called the minor inconclusive. The next one is D16, at which I have a 9, 11, 13, and Brandy's type is 9, 13, so the minor component is an 11 plus. Mr. Avila Quinones at D16 is 9, 11. I could not use this for statistics because the 11 is a starred allele. At TPOX, the alleles I recovered are 7, 8, and 9.
We're talking about THO right there?
Oh, I'm sorry, THO, correct.
And you started to say the major component at THO is the 7, 7, is that correct?
Yes, the major component is 7, 7, and Brandy's type is 7, 7. So the minor component is 8 and 9. But the 9 is a starred allele, so I could not use this for statistics. Mr. Avila Quinones at THO1 is 8, 9. That's his type. The next one is TPOX, and I have an 8, 9, 10 alleles at that locus. The major is Brandy at 8 and 10, so the minor is a 9 plus. And Mr. Avila Quinones at TPOX is 9, 11.
So his 11, as we're going across the screen again from left to right, is dropping out there.
Yes, this 9 is only at 66 RFUs. So it's possible that the allele that goes with it has dropped out.
Yes, ma'am.
At CSF, I have only an 1114, which is Brandy's type, and therefore I called the minor inconclusive. At D7, I have 10, 11, 12. Brandy's type is 11, 12. That is the major, and the minor would be a 10 plus. And at D7, Mr. Avila Quinones is 8, 10. So based on that, I did include him as a possible contributor. The rules for FDLE's inclusion is that it must have a statistic to go with it if it's an inclusion. And the two loci that I mentioned I could use that did not have any starred alleles for statistics would be VWA and D8. However, I could not calculate a statistic now because I don't have access to the software that does that.
Okay, so we can't say frequency of occurrence, but you can determine based on callable allele for inclusion purposes, that is allele that are above 100 RFUs, we can say that Mr. Avila is included as a contributor to that mixture, is that right?
Yes, and it is significant to me that even the starred alleles, he has those alleles also.
And if the starred alleles had not matched, you would have been able to exclude him on the basis of those. It's proper to use starred alleles for exclusion, correct?
Yes, that's correct.
And even with all those starred allele that we saw, none of them were inconsistent with his profile such that he would be excluded.
That's correct.
Okay. I was going to ask you briefly about a couple of exhibits real quickly here that were not in evidence when you testified before. In evidence now is Defense Composite Exhibit 23, A through E. These are some latex gloves that were found at Tom Brown Park. Do you have your report wherein those gloves were processed?
What would the TPD number be?
TPD Exhibits 7A through 11A, FDLE 175 through 179. And I'm particularly interested in TPD 11A, FDLE 179. Which would be the Defense Exhibit 23E as part of that composite.
For the TPD Exhibit 11A, I did not get any DNA results.
It did test positive for blood though, correct?
Yes.
Okay.
So these are latex gloves.
Yes, sir. And that's, of the composite exhibit, that's the E designation. The submitting agency, TPD, never requested touch DNA testing for any of those exhibits, correct? And so none was performed?
I'm sorry, what was the question?
I was just asking, you tested for blood, you swabbed the blood, but no touch DNA was touch DNA swabs were taking. In other words, the glove wasn't turned inside out and swabbed on the inside for possible touch DNA.
Well, just a minute, I'll have to find that. That's correct.
Okay. And there was also a possible hair identified with that exhibit, is that correct?
5 possible hairs.
And the submitting agency, TPD, didn't request that any of those be tested, correct?
Correct, and since there was blood evidence, the hairs were not considered to be more probative than the blood.
Right. Okay. And then switching to what's in evidence is Defense Composite 24A through F. It's TPD 12A with no designations for the individual gloves, FDLE 180. They listed 6 gray gloves from Jack McLean. You identified 7 within the packaging.
Correct.
And you were able to identify blood on at least one of those?
And you said 24, that's 25. Right?
Is it
24 was the latex gloves, 25 was the gray glove.
Yes, sir, you're correct. Sorry about that. Defense Composite 25.
What was your question?
You were able to identify blood on at least one of those, is that correct?
Yes, on 3 of them.
Okay. And there was enough there to get at least a partial profile with some starred alleles so that you could do exclusion?
From 8 areas of the gloves, I had no DNA results. And I had some limited DNA results from 1 area of the gray gloves. Limited basically means I can exclude, but I cannot include people.
Okay. And you were able to exclude all 4 victims and Mr. Segura from being a contributor to that partial profile, correct?
That's correct.
I have no further questions. Thank you.
Ms. Brown, did you include the children in your analysis of, and your determination as to exhibit number, one A and B, which is the Tallahassee Police Department exhibit number 33?
I'm looking at my report. Sorry.
It was the one, it was the electric fairground that you were talking to Mr. Prince about.
Yes. I have it in a different file, I'm afraid.
It's a little complicated. They have hundreds of samples they're looking at. It's a little bit complicated.
It was a mixture of DNA, which was indicated the presence of at least 2 individuals. If I assumed 2 individuals to the mixture, I was able to determine the major, which matched Brandy, and had a partial DNA profile for the minor contributor. I excluded the children, Tanaya, Tamaya, and Javante, as possible contributors, although I might have included them if those alleles had been above the callable limit.
Are they there or are they not?
Because alleles that are consistent with some of the girls especially are starred alleles, I can't say they are included.
In looking at making a determination about whether or not 1 or more persons are present, 2 persons versus 3 persons, isn't it true that when you're looking at 1 particular person, you're looking for 2 peaks? When you're looking at 2 persons, you're looking for 4 peaks. And typically, when you're talking about more than 2 persons, you're looking at instances with 3, there are 5 or 6 peaks.
That's not true in this case.
Okay. In this case, though, you assume 2 donors, correct?
Correct.
Okay. One of those is Brandy.
Correct.
And then, of course, the other one is the minor contributor. And we see right here at VWA, the minor you concluded was a 14 and a 17, correct?
Yes, but as I explained, I was trying to take into consideration that the girls 14 might have shown up at VWA.
Or it could be the minor contributor, as you labeled here, with the 4 peaks as being a 14 or 17, correct?
It might be.
Okay. And Mr. Avila doesn't have a 14, does he?
No, he doesn't.
And Brandy does not have a 14, does he?
Does she?
She, excuse me.
No.
Okay. So your original conclusion was the minor is a 14-17, and if in fact the minor is a 14-17, Mr. Avila cannot be that minor, can he? Because he is a 17-18.
Well, in my opinion, it was important to take into consideration that this was off of a phone, which was in the home, that the children might have touched, but there might not have been enough DNA for me to be able to say they're included. There were some alleles which were starred alleles that if they had been higher, I could have included them. But according to the rules of FDLE, I cannot use those starred alleles to include anyone.
Okay. Let's talk about peak proportionality that Mr. Prince talked about previously. When you're talking about someone of a mixture in this situation in which there are in fact two donors, one of which the major, 15-18, those peaks are proportionate to each other, correct?
Yes.
Consistent with being the same?
Yes.
The minor as a 14-17 are proportionate to each other in the fact that they are roughly the same amount, correct?
That is correct. However, there's different interpretations of that.
Certainly. And let's talk about interpretations. You're no longer with Florida Department of Law Enforcement, are you?
Pardon me?
You are no longer with Florida Department of Law Enforcement, are you?
I have retired.
And in fact, that retirement was requested because of the fact that your handling of this very same.
Exhibit number 33, was it not?
No.
It was not.
No.
All the issues that were created out of these exhibits at the phone cradle is not a part of that retirement aspect.
No.
Okay.
Let's talk again, if we will. Let's move on to D5. D5, you made a determination that the minor was a 7 and a 12, correct?
I did not
There's
determine.
Carlito's.
I did not determine that a single minor person had both the 7 and the 12.
Okay, but you made the determination that the major was an 11-11, correct?
Yes.
Okay. And you made a determination that there are two donors, correct?
You have to say what you are assuming in order to interpret the mixture.
Okay.
If I was able to do it according to how I felt, I would have said there were, in fact, I said in my report, at least 2 donors.
Which is not the children, is what you said in your report, correct?
Well, if you remember what I said, I would have included the children if I could have. However, the rules of FDLE are that if there are starred alleles, you cannot use those for inclusion. So
And what
I
you said-
therefore had to say that they were excluded.
Correct. They were excluded. So if you exclude them, and the major is an 11-11, and the minor is a 7-12, Mr. Avila is an 11-12, correct? He's not a 7-12, is he?
But he is included, out of those 3 alleles, he is included in those 3.
But he's not included in that fourth one, is he? Which if you have 2 donors, you've got 4 alleles.
No, sir, that's not correct.
Reader. I was asking if we could approach regarding Mr. Dave Strauss. Ms. Brown, I want to ask you about the suggestion that perhaps you did something wrong on this case. Can you tell the jury what CODIS is?
Yes, CODIS stands for Combined DNA Indexing System. It is a computerized accumulation of both crime scene evidence and also standards from convicted offenders that are all the alleles that you see that are developed, the 13 alleles, are put into CODIS, and they can be searched against each other. So, for instance, an unsolved crime that has a particular DNA profile might match to a convicted offender.
And even back in 2010 and 11 and 12, when these samples were initially run, there were millions and millions and millions of offenders in the national database for CODIS, correct?
I believe so, yes.
Okay. you were actually the CODIS administrator at that time for the Tallahassee Biology Lab, is that correct?
Yes.
And can you tell the jury what a CODIS administrator is?
The CODIS administrator checks to see what kind of matches may have happened when your DNA samples that had been entered that week were searched against the database. And once they are determined, we have them confirmed by a section of the laboratory called the DNA database. And then we send out letters to the agencies telling them that we have identified the profile that was found at the crime scene.
At least that's what the FDLE operating procedures required, correct?
Yes.
Okay. And can you tell the jury the difference between the requirements for the local CODIS database, the statewide, and then the national database?
There are different numbers of loci required to be able to be searched. 10 are required to search at the national level. I believe it's still 7 are required to be searched at the local level. What that means is, local level means that you're searching the DNA profiles made up in your own lab, or determined by your own lab. Then there's a state search which tries to match your DNA profile from your evidence against all the state profiles that have been uploaded. And finally, the third stage is to search your DNA profile at the national level.
And to enter a sample into the national level, it requires the largest number of loci present, correct?
Correct.
So you'd have to have more of a profile to enter it in the national database.
Correct.
And as the CODIS administrator for the Tallahassee lab, you were the person who knew those guidelines best and was kind of the gatekeeper as to which samples would go into each of the 3 levels of the database. Is that right?
Yes.
Okay. And you actually did enter this sample, the one that we were just talking about, the swab of the foam cradle, into the national database because it met the criteria, correct?
I did.
And you got a hit?
Yes, I did.
Okay. And when you get a hit, what is supposed to happen?
The CODIS administrator is supposed to write a report to the agency that submitted the evidence, telling them that you have matched, you either matched to another case or you matched to a person in the database.
And the submitting agency then can request a buccal swab from that individual, right?
That's correct.
In any event, it's an investigative lead that the submitting agency is supposed to be apprised of,
Correct.
so that that information can be provided to the state attorney and ultimately the defense, correct?
Well, I'm not sure what all they do with it, but we have to inform the agency, yes.
And that isn't a discretionary call, that's something that was specifically provided for in the FDLE operating procedures, correct?
Yes.
With which you were especially familiar as the CODIS administrator.
Yes.
When you got a hit for this particular sample, did anyone prevent you from complying with FDLE operating procedures and providing to the Tallahassee Police Department notice of the investigative lead, notice of the hit?
Yes, I had written a letter. My supervisor took a look at the profile, saw that there were a lot of starred alleles there, and took it to his supervisor, who was the chief of forensics at FDLE at the Tallahassee lab. And she told me to not send the letter.
That was Karen Martin, right?
Her name is Karen Martin, correct.
How much experience did Karen Martin have relative to you?
She had more experience than me.
But you were the CODIS administrator, right?
Correct.
Okay. And it was ultimately determined that her failure to notify the agency, or differently stated, I suppose, her preventing you from properly notifying the submitting agency in accordance with FDLE operating procedure was a violation of those procedures, correct?
Yes.
And to correct that problem, you yourself actually had to go notify Mr. Campbell, the state attorney handling the case at the time, to see that the defense was notified of the investigative lead. Is that right?
I took it upon myself to verbally telephone him and tell him about it, yes.
And if not for you going out of the way to comply with FDLE's operating procedures, that lead could have gone unknown to everybody, unknown to the state attorney, Mr. Campbell, and unknown to the defense.
Correct.
and that would have prevented Mr. Campbell effectively from utilizing law enforcement resources to get the buccal swab from Mr. Avila.
He probably would not have.
Yes, ma'am. And just to be clear, although you're no longer employed by the Florida Department of Law Enforcement, it had nothing to do with your compliance with the standard operating procedures, correct? You just retired because you'd finished your career.
I retired because I reached the age of 62 and I wanted to retire.
Yes, ma'am. Similarly, with respect to your testimony here today, the party paying your expert witness fee is the state attorney, correct?
Correct.
You're not being paid a single dime by the defense, correct?
Well, I could bill you for expert.
You could bill me. Fair enough. You haven't been paid anything, right?
I have not been paid anything yet.
And you have not submitted a bill to me, correct?
Correct.
Thank you. No further questions.
Hey, Jerry, I have a question. Right, you can step down. Do we need her further?
So she can be released.
You need her. All right, you're excused.
Thank you.
Are you next witness?
That's what we call Kevin Noppinger.
Up here, please. Have a seat. You remain under oath. Just for record purposes, if you state your name again, please.
Kevin Noppinger.
You may proceed, Mr. Prince.
Up on the screen here, Mr. Noppinger, we have what's been entered into evidence as Defense Exhibit 12. It's the profiler page of the swab of the bath bar. And I want to get your unique perspective on one issue as it relates to the interpretation of this data. We didn't really get into this before, but you were previously a lab accreditation auditor, correct?
Yes, sir.
Can you tell the jury what that means?
Crime laboratories in the U.S., you have to be accredited. So you have to be audited. So part of that is I was on audit teams, did 15 labs throughout the U.S. The inspectors go in, there's quality assurance guidelines the FBI requires DNA laboratories in the U.S. to follow. So we would go in, ensure they do validation studies, have proper protocols, procedures, whole list educational requirements, contamination logs, and we would go through the laboratories and audit them normally 2 to 3 days, depending upon the laboratory, how big they are, and make findings if they were in not compliance with the FBI guidelines.
And if a lab was not in compliance with those guidelines, they could potentially lose accreditation, correct?
Yes, sir.
Okay. One example of an issue that could potentially lead to a lab losing accreditation is if they fail to follow the interpretive guidelines that were validated for use with their instruments. Is that true?
Yes, sir. It'd be a finding. Yes.
Okay. And the reason is that those interpretive guidelines that are validated for use, that's not some kind of quick, sloppy process, correct? Reliable results cannot be produced through interpretation that are not based on the interpretive guidelines for use with that kit and instrument. Is that correct?
Yes, it takes months for a new kit to validate.
And can you talk about some of the variables relative to the instruments that may impact, for example, what the inclusion threshold would be for that particular instrument?
You mean how you would go about doing that?
Yes, sir.
Well, when you do validation studies, you have to do studies on sensitivity. You have to do studies with mixtures, 2, 3, 4 people mixture studies. You look at baseline noise. The instruments have their electrical signals, baseline noise. There's some what we call spikes, electrical signals sometimes that come up. So you have to evaluate all of those criterias. And after your validation studies, you make your standard operating procedures, your interpretation guidelines that you've developed from the validation study.
And so You referred to some kind of static, also referred to as white noise. Can you tell the jury in a little more detail what that would mean and how it could potentially impact interpretation of peaks?
Well, it's sort of like I said before, a mixture is because you have two alleles, when you see three alleles at two or more loci, because sometimes you could get some noise that might be there. So your reliability is better if you have at least two extra alleles. So again, some are based on electrical signals, some are based on charges or artifacts that might be in different solutions or in the extraction.
And those factors are going to vary widely from instrument to instrument, kit to kit. Is that correct?
Yes, as well as the way the substrate, the samples are taken too. It could.
And it's for that reason that SWGDAM requires anybody interpreting a data set from within a lab with a particular instrument to follow that lab's guidelines, because those guidelines have been put in place to ensure reliable interpretation.
Correct, their own laboratory guidelines, yes.
And if somebody isn't aware of all of the different variables that can impact a reading with a particular instrument and with a particular kit, ignoring those guidelines could lead to unreliable interpretation, correct?
Yes, sir.
And doing an interpretation of that sort, as indicated, could potentially cost the lab their accreditation. They could no longer testify about their results in court if they lose their accreditation, correct?
Well, that's a court issue, but they could lose their accreditation, yes, it would not be good for the laboratory.
Okay. And ultimately, you agreed with Joellen Brown's interpretation of this sample that Mr. Segura could not be included, correct?
Yes, sir.
No further questions.
Go ahead.
Okay, first and foremost, we're talking about the grab bar, correct?
Yes,
Okay. You're saying he cannot be included?
from that particular sample?
Yeah.
I think the data is pretty, well, it's limited data on there. There are some alleles that are present, but there's a limited data on that particular sample.
Mr. Prince actually made two different statements. That you would agree that Ms. Brown testimony that he cannot be included. That was not her testimony. Her testimony was she could not exclude him from this sample.
From the grab bar?
Yeah.
Oh, I thought you were talking about the other sample. My mistake. I would have to look at well, I agreed with with Joellen Brown with her interpretation of what I reviewed in the report.
That Mr. Segura cannot be excluded from this sample.
I mean, I haven't reviewed my results on that, but I agreed with everything in her report, yes.
Okay.
Pretty direct.
Just very briefly, just to be clear, and I know we lawyers can get a little bit loose with the language sometimes. Not included and not excluded, those are two sides of the same coin, correct?
Yes.
Insofar as it puts you in a position where you can't make a determination about somebody's potential contribution due to a lack of callable allele, that is, allele for inclusion purposes over 100 RFUs, correct?
Correct.
And any attempt to include somebody in a mixture is going to be further complicated if related persons are donors to that mixture, correct?
Yes, sir.
And similarly, when you have prevalent dropout throughout a sample combined with multiple related persons donating to the mixture, that's going to make it even messier, correct?
Yes, sir.
No further questions.
Any jury questions? Accept that? Oh, you're not good?
It's time the defense will call Greg Maimone.
Say that again.
Greg Maimone is yeah, I'll let him say that. I can't spell it.
Is he gonna be referring to this?
Sorry,
Is he gonna be referring to this exhibit?
yes, it looks like we will. Now.
Okay.
No, not with this exhibit. He's got
Yeah, that's what I was saying,
Yes,
let's
sir.
pull that exhibit. He's not gonna stop that. Come on up here, please. Raise your right hand and be sworn, please.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
Have a seat, sign up the rest, please. Proceed.
Thank you, Your Honor. Sir, can you please state and spell both your first and last name for the court reporter?
My name is Greg, G-R-E-G, Maimone, M-A-I-M-O-N-E.
And what do you do for a living?
I work for the Florida Department of Law Enforcement, assigned to the impression evidence section.
What does that mean?
It means I receive items of evidence from agencies. I examine those items of evidence for the presence of footwear or tire tracks. I then compare those to any known footwear or tire that's also submitted.
And did you have to go through any particularized education, training, or certification to be able to offer opinions about that type of evidence in court?
Yes, I have a bachelor's degree in physics from the University of Virginia. I have a master's degree in forensic science from George Mason University, and I completed an approximately one-year training program with FDLE.
And do you have to maintain certain certifications with FDLE or some other governing body in order to be able to continue testifying about your opinions as it relates to this type of evidence?
No, we do not.
Okay. Have you been previously qualified to testify as an expert in this area in court before?
Yes, I have.
Okay. Approximately how many times?
Approximately 19 times.
And how many other cases beyond those you've actually testified in have you worked on?
Hundreds.
All right. Now, when you say that you've worked on cases and you've testified in court, who is it that you testify for?
I've testified for both the state attorneys and defense attorneys.
Generally speaking, as a member of the Florida Department of Law Enforcement, it would be a state attorney's office or a law enforcement agency submitting evidence to you for review. Is that correct?
The majority of items, yes.
Okay. And that's what happened in this case as well, right?
That's correct.
When were you first involved in this case?
Was involved in September of 2017.
Okay. And what materials did you receive from either the submitting agency or the state attorney?
I received a DVD and two sets of footwear standards.
Can you tell the jury what footwear standards are?
They are representations from a person's shoes, recorded in this case, it appeared to be ink on paper, but there are many ways to do it, but it's just a representation of the shoes someone was wearing or has.
And so the reason a shoe impression standard would be taken is to be able to determine whether those shoes resulted in impressions being left at a crime scene. Is that right?
It's generally why, yes.
And do you have those shoe impression standards with you?
I have photographs I took of them, yes.
Okay. Can you pull those out? Do you have to keep those?
No.
For identification, then we'll refer to this as Defense Composite Exhibit 31A and B. What are those things that you're looking at right there?
These are photographs that I printed after scanning the footwear standards,
So these are exact replicas of the actual standards themselves?
as close as can be, yes.
Okay. And are they a true and accurate depiction of the shoe impression standards?
Yes, they are.
This time, Your Honor, I would request to move into evidence as Defense Composite Exhibit 31A and B. This is,
May I be admitted?
report of information published, Your Honor. So first we'll look at I don't know that we're going to be able to fit both on there, but we do the best we can here. So I guess let's start with, what are you looking at when you first get a set of standards like this, before you try to compare it to anything found at a crime scene? What types of characteristics are you looking at?
The class characteristics are the first things I look at when I'm doing comparisons.
What does that mean? What's a class?
Class characteristics are those items put there during the manufacturing process. So when a company manufactures a shoe or a boot or a tire, they put things there on purpose. They make a design and they put that onto the shoe, onto the bottom of the shoe. Those are those class characteristics. So it's the design of the shoe, the physical size, how big those elements are in the shoe, whether it's a left shoe or a right shoe, things of that nature.
Okay. And the shoe impression standards you received in this case, They were from the first responding officers to the crime scene, is that right?
I don't know.
It does have the officer's information down at the bottom here. We have Officer Jernigan, and the other set was from Officer Kidd, correct?
That's correct.
Okay. Using these shoe impression standards, were you able to conduct any comparison to pictures of impressions left at the scene of the crime in this case?
Yes, I was.
Okay. What photographs did you use in order to conduct that comparison?
I used photographs, well, and this is going to be referring to it from the CD that was submitted to me. Photographs 993, 994, 997, 1156, 1161, 1164, and 1165, 5763, 5771, 5822, and 5832.
And it doesn't look like you have those photos right there in front of you, is that correct?
I do, yes.
You do have them?
Yes.
Oh, okay. Can you pull those out? Can you give these away as well?
Yep.
How many do we have there? I had to calculate it for a second there. Okay, so for identification purposes, this will be Defense Composite Exhibit 32A through K. Can you, before we put those in evidence, can you tell me if those are fair and accurate depictions of the impressions that you used for comparison to the standards that we just looked at?
They are.
All right, I would request permission at this point to put those into evidence as Defense Composite 32A through K.
Any objection?
No.
To be admitted?
Request permission to publish.
Do that.
What is this first one we're looking at here?
It's an area of carpet that was photographed.
And were you able to draw any conclusions about the type of impression this was?
I determined that there was not enough information to determine whether or not there was an impression there.
Okay. And that's common. Not every impression can be definitively characterized. Is that
That's
fair?
correct.
Okay. For subpart B, what do we have there?
It's another area of carpet that was photographed.
Were you able to form any opinions about this one?
Again, there was a determination that there was no clear, distinct footwear impression or features there.
Okay. Subpart C. This one's a little faint, but were you able to make a determination about this one?
There were apparent impressions of unknown origin. What that means is there's some kind of pattern that's visible on the tile there. I was unable to determine whether it had a distinct source of a footwear or a tire or something else. But I was able to get enough information to compare it to the footwear impression or the footwear standards that were submitted.
And although it's difficult to see on the overhead, we can see the curved impression right there. There's just not enough detail to be able to make out a tread or anything like that.
Correct.
Okay. Since this is the first identifiable impression, were you able to, even though you couldn't identify this as a shoe impression for sure, were you able to compare this to the shoe impression standards?
I was.
And were you able to make a determination about the possible contribution of those shoes to this impression?
The footwear standards or shoes represented by the footwear standards were not made, could not have made the impressions of an unknown origin in this photograph.
Okay, that was for subpart C. Subpart D here, what do we see?
So this is another area that was,
Is that better?
yeah. This is another area that was photographed. It appears to have been powdered prior to this photograph. There are areas on the photograph that have some kind of distinct manufactured pattern appearance. So they have linear lines. They don't look natural in origin. And I determined these were, again, apparent impressions of unknown origin.
Okay, and were you able to conduct a comparison to the shoe impression standards you have?
I was. The shoes that are represented in the standards could not have made those impressions.
Okay. Subpart E, Were you able to make any, draw any conclusions about this potential impression?
This is another apparent impression of unknown origin. You see the 3 lines kind of in the middle. My designation is that red.
Pointer there, you're right,
There we
Andrew,
go.
that would help.
There we go. I'll try not to hit you in the eye. So this red star right here is my marking.
Step over there so I can see.
Did everybody see? Okay.
So this red star is my marking, and I'm marking these areas right here of these, for lack of a better term, lines that are on the tile there. Again, it's an apparent impression of unknown origin. I don't know if it's a shoe, tire, something else. I was able to compare this to the footwear standards, and the shoes represented in the footwear standards could not have made those impressions, or that impression.
How about for subpart F here? Were you able to make any determination about this potential impression?
There's an area right here that, again, is an apparent impression of unknown origin. So there's some kind of residue or something that came in contact with the tile there. It's an apparent impression of unknown origin. I compared it to the footwear standards, and the shoes represented in the footwear standards could not have made that.
Subpart G.
Another area here, and these kind of vertical lines going through, and then this has some squares or triangular blocks in that area there. Again, apparent impressions of unknown origin. Was able to compare it to the footwear standards. The footwear standards could not have made those.
Subpart H.
So the area I was looking at was this area here, but I was unable to determine whether that was an impression or there's some broken glass or broken something in this area as well. And I was unable to determine whether this was a footwear impression feature or just from the residual glass. So I determined there was not enough information to determine if there was an impression there.
Okay. Subpart I.
So again, this is another, I believe this is an area of carpet that's photographed again, and there was not enough information to determine whether or not there was an impression here.
Subpart J.
So here we have this area in question and this area in question. This is apparent footwear. It has the appearance of either a side or a toe or a heel of a footwear impression, but I can't determine it is definitively a footwear impression. And there are 2 areas in question, the left side of this tile and the right side of that tile. I was able to determine that the shoes represented in the footwear standards could not have made those.
Okay, and lastly, for subpart K.
It's the same area exactly. It's just a second photograph that I printed out. So those 2 areas are the same. It's just one's before processing and one's after processing.
Okay, so the shoe impression standards were likewise excluded from that one?
Correct.
Now, in looking at those, you indicate that they're impressions of unknown origin. Do you agree that even though you weren't comfortable definitively classifying them, that many of those impressions had characteristics of a shoe impression or a footwear impression?
They could be shoes. They could be any number of things.
Okay. But even when you can't make a call about a class of footwear or definitively characterize an impression, you can do exclusion comparison like you were just testifying about.
That's
right?
correct.
Okay. And to be clear, you're employed by the Florida Department of Law Enforcement
That's correct.
and have not been hired by the defense.
I
Your
have not.
statement is correct?
Yeah.
Thank you. No further questions.
Yeah. You kept saying impressions of unknown origin.
Yes.
Marks on the carpet is what they are. Don't know where they're from.
Some of them, yes.
Okay. I know there's one you said was in fact a footprint.
And it's an apparent footwear
Okay.
impression.
All the other ones, other than that one spot, are marks on the carpet, marks on a tile of unknown origin. You don't know what caused them.
That's correct.
Can't say they're footwear. Can't say they're not footwear.
Correct.
Just something.
Correct.
Okay. Then you had one spot that actually has 2 photographs there. That is a shoe impression.
It's an apparent footwear impression.
Okay. There's 2 photographs, but we're only talking about one spot, correct?
Correct.
Okay. Nothing in your analysis indicates that there are 5 different types of impressions or footprints of shoes going in all different directions, is there?
No.
So what we have is one footprint made in the house that is not the 2 law enforcement officers.
One footwear impression and other impressions.
But correct, okay. So the one that we clearly say has the indications of a footwear impression with the 2 photographs.
Correct.
So we have one footwear spot there. We know it's not the law enforcement officers.
Correct.
Okay, no further questions.
Redirect.
Ordinarily, if a law enforcement agency or state attorney's office is interested in determining the potential contribution of a suspect or a defendant to a probable footwear impression, you'll not only get standards from law enforcement, but they'll send you standards from the defendant's shoes as well, correct?
That's correct.
And that's why ordinarily, if they execute a search warrant at a defendant's home, they'll collect those shoes and either send you the shoes or impressions of them. Is that correct?
How they obtain the shoes, I don't know, but yes,
Okay. And that didn't happen in this case, correct?
that's correct.
No further questions.
All right. Did you have a question of this witness? You want to step in? Do we need to keep him any further?
No, sir.
Any further? You excused? Got another brief witness?
Not that brief, and he can stay over if the court wants him to. I mean, I think.
Well, let's go sidebar.
Yes.
We're gonna let you go to the audience, please. You can move to the audience. Okay. All right. Lawyer said they're tired, they want to go home, so anyway. We'll see you in the morning, 8:45. Don't discuss the case with anyone. Don't let anyone discuss it with you. Have a good evening. All right?